peace and blessings of God be with you. On behalf of the Steering Committee of the International Permanent People's Tribunal, that is based in Rome, and the Malaysian organizing committees comprising of the International Movement for the Just World, JUST, Center for Human Rights Research and Advocacy, CENTRA, and the International Buddhist Muslim Forum, Myanmar, I wish a warm welcome to everyone here for participating in the International Tribunal on State Crimes allegedly committed against the Rohingyas, Kachins, and other groups in Myanmar. We are all here today to affirm our support for the struggles, liberation, and justice of peoples and communities experiencing the absence of the powerless international law. In the effort of organizing this event, the Malaysian Organizing Committee wishes to offer its sincerest appreciation and thanks to the Acting Vice Chancellor of the University of Malaya, Professor Awang Budiba, the Dean of the Faculty of Law, Associate Professor Dr. Johan Shamsuddin, for the support and cooperation. Appreciation is also due for efforts from members of the three organizations, JUST and the Center for Human Advocacy, Human Rights Centra, Rights and Advocacy, and the International Forum on Buddhist Muslim Relations, who have all worked hard to make this event, to organize this event. Now, before I hand over the mic to Dr. Gianni Gogoni, who is the Secretary General of the Permanent People's Tribunal, will explain to you or introduce you to this tribunal. Allow me to make a few housekeeping announcements, like please switch off your phones and keep all phones on silent mode. Kindly note that no private photography or private recording on your phones or other personal device is allowed in this courtroom. Kindly respect the privacy and anonymity of our witness, from some of whom have risked their lives to come here. And usual announcement will be no food and drinks into this room. And each of you, I think, have been given a card. So please use this card as a free ticket to come in and out of the school for the next 4 days. So if you use your card, it's a ticket to come in. And any other inquiries, please go to the front desk. Okay, and I now call on Chief. Dr. Zani?
Johnny? Johnny, where's Johnny?
I think Dr. Johnny has some announcement about tonight's event. Would you like to say that before we can go?
Good morning, everybody. We have a very tight schedule for the whole day and the next 2 days. I just have a special announcement to make. We have the entire high-powered delegation from the Bangladeshi Human Rights Commission, led by the Human Rights Commissioner himself. They just arrived here tonight. This morning. He will be here around 2 o'clock, and then one of their delegates will testify on the profound impact that the Burmese situation is having on the lives of Rohingyas, numbering 800,000 now, including the the existing population. And tonight they will be having an extraordinary event, making an appeal to the international community about the extraordinary challenges that have been thrown on their lap by the humanitarian catastrophe originating out of my own country. So that will be at the Institute for Integrated Malaysia at 8 o'clock until 9:30. Again, National Human Rights Commission from Bangladesh will be making a special appeal tonight at the Institute for Integrated Malaysia from Institute for Integrity Malaysia from 8 o'clock until 9:30 p.m. Thank you. Johnny from Permanent People's Tribunal. Johnny is the Secretary General of the Institute. He will be introducing the judges. Johnny. Yeah.
Good morning to everybody. I am Gianni Tognoni. I am the Secretary General of the Permanent People Tribunal. It is my duty to say a few words to explain, to present what has been the origin and then the specific role of the Permanent People Tribunal, so that you will understand possibly better the overall function of this session. The Permanent People Tribunal is a directly follow-up of the experience of the tribunal which were established for the Vietnam and then for the dictatorship in Latin America by Bertrand Russell, Sartre and other groups back in the 60s and the 70s to declare that it was necessary to have an independent court in international scene because the states were in fact defending in international court of situation their interest and many times violating the rights of the peoples who were supposed to be represented by state. The idea of the Permanent People Tribunal originated from those experiences on the basis of a Universal Declaration of the Rights of Peoples in '76 in Algiers, with the idea of making the effort and the purposes of the tribunal on Vietnam and Latin America something permanent. It was clear already at that time that the possibility of a contradiction, and many times very dramatic contradiction, between the interest of the state supposed to represent people and the interest of the people could become a permanent threat for the right of people. And in that sense, the Permanent People Tribunal started its work in '79 with a statute which established that it was important to have a tribune where more than condemnations of people who were responsible for violation, because the opinion tribunal could not have a real power of enforcement in front of the state laws, but at least to give the world the visibility and the recognition of the right to people in order to help their struggles looking for a different solution to their problem. Since then, the tribunal received and accepted, following careful examination, many requests, and now we have an experience of so many years, more than almost 40 years, with more than 40 cases which have represented, in fact, the full spectrum of the violation of fundamental rights. We have faced a different situation. It's not here, obviously, the time, not the opportunity to recall, but it's important possibly to have the idea that the tribunal was in fact in charge of cases which have prepared somehow these specific sessions, because we had many times the opportunity of seeing the contraposition between the state and part of the population which were in fact declared enemies of the state, and in that sense which were persecuted and in fact many times dramatically repressed in all their rights and their lives, starting from the Argentinian case of dictatorship in '81, when the desaparecidos, those who disappeared from the visibility itself and the recognition of their existence, because they were denied existence on the basis of political reasons. Then we had the opportunity of looking back to genocide which was denied by the international community, such like the Armenian people, and then we were the first one to collect the request of the Armenian diaspora to re-qualify what had happened and denied the international community. The case of the Guatemala and other situation where in fact the situation of so-called minorities were in fact repressed. I think that I have to give more direct space to the judges who are here. I have, however, to announce some important information for the overall organization of this session. This session has been prepared with long work, starting back in Oslo and then in London, and specifically with an opening session in London last March, where the first public hearings on the case on repression by the Myanmar state on Rohingyas, on Kachins and other ethnic groups was adopted as a formal case of the tribunal. We received all the documentation, and according to the procedure, we organized together with obviously the protagonist, the local organizing committee, this session. Two things are important. We have clearly respected the general rules of the tribunal, and we have communicated early on the procedure of the tribunal to all the authorities who are concerned, and especially we have communicated not only the hearings but also the right to present their defense to all the authorities of Myanmar. I apologize for the pronunciation. Senator General Aung Kyaing, Commander-in-Chief, Aung San Suu Kyi, Minister of Foreign Affairs and Myanmar State Councilor, and then to the Vice President, to General Mai Tun O, to Wim Ra, Chairman of Human Rights Commission, and we have communicated all our procedure and the invitation to be present, and some of them are responded to the Secretary General of the United Nations, to the United Nations High Commissioner for Human Rights, to the responsible for the European Union for Foreign Affairs, Mogherini. Last information, which is very important and which must be taken as an important communication. As you will see, the composition of the panel of judges today is made up of 7 judges. 2 of those were supposed to be present and are listed here could not be present. One, Dennis Halliday, because he's undergoing surgery in these days in New York, so he obviously was forbidden to be here. And then the Indian representative, Velur Krishna, who didn't get the visa despite many information to come here, and he also sent his greetings. But possibly the most important communication is one which is, from our point of view, very important, and we have to thank for the acceptance. We had yesterday preparatory discussion with the members of the jury, with Chaudhry Abrar, who was invited to be part of the panel of the judges, and we discussed with him openly and clearly the possible importance for the tribunal to have him even more than a judge as a representative really of those who are involved, and to act as an expert witness. And in that sense, we have to thank him really for not only accepting but volunteering to play this role in this meeting, because that is even more consistent with the characteristic of the tribunal to represent people who are involved. Bangladesh, who is from Bangladesh, is not part of the accused party directly, obviously, but is part of the big scenario. It is important for the tribunal to have a direct and competent presentation of what's going on, so we have to thank him. And now I think that the tribunal, despite the few words I have said, is ready to start, and I will be happy to then introduce the judges as soon as they will be taking their place. Thanks for your attention.
Please rise.
I think that useful simply then you will find all the information to present the member of this panel of judges. The panel of judges is selected in full independence by the Presidency and the Secretariat of the Permanent People Tribunal, based on the criteria of competence and independence, and in that sense we have tried to make our best in this situation. The chair has been indicated by the members of the panel, Daniel Feierstein, who is from Argentina. He has a long experience in this field, has been president of the International Society of Genocidal Studies. I don't mention neither for him nor for the other members all the titles. Then we have Ellen Jarvis, who is on the left of Daniel, who is an important person from my point of view because of the various charges from Cambodia and Australia. She is living now in Cambodia. She has been acting in international court and has been active also as a member of the Permanent People Tribunal in many other audiences, including that on Tamil. Then we have Jill Beringer, who was head of the law school in Sydney, Australia, and has been teaching in many places, and is also since long associated with the Permanent People Tribunal. We have then, here on the left, Shadi Sadra, who is an Iranian human rights lawyer, was a master in international law, and she is also now living in UK and is very, very actively involved in opinion tribunal. We have then, and I apologize for the pronunciation, Nushabani Katsingana, that she is from Indonesia, human rights lawyer, and working in many NGOs committees. We have then Nello Rossi, who is from Italy. He is a Solicitor General at the Supreme Court of Cassation in Italy. He has been also working with the tribunal in other hearings which are very close somehow to this in Mexico. And then the last not least, obviously, because she is from here, she is from Malaysia, Zulaya Ismail, who was trustee of the Perdana Global Peace Foundation and is certainly best recognized by you. So that's the end of my presentation, and now I think that the direction is obviously in the hands of the chair and of the panel of the judges.
Okay, good morning to everyone, and thank you, Gianni Antonioni. That's the official start, and I welcome the Permanent People Tribunal session on state crimes allegedly committed against the Rohingya, Kachins, and other groups in Myanmar. So I see that the prosecution team is here. So first of all, I have to ask if any member of the government of Myanmar is present in the audience to take care of the defense. No, so it seems they have been invited, I understand. Yes, so we asked the secretary of the tribunal if it is possible to prepare presentation for the defense with the arguments of the government, even if they are not willing to recognize the jurisdiction and the importance of the tribunal. So, second, before starting the first session, and in the name of the whole panel of judges, I would like to thank to Professor Chowdhury Abrar, who decided he was appointed to be a member of the panel of judges, but in a conversation with the panel, decided to preserve the objectivity and the different accusations that could be done against the tribunal. He decided to recuse himself and to give a testimony as an expert witness, which he thought it would be more useful for the tribunal, and the panel have agreed that. But we really appreciate his decision, and we would like to thank him in the name of the whole panel of judges. So I will give the floor to the chief of the prosecution team, Doreen Chen, just to start the first session of the hearings.
Thank you, Mr. President. On behalf of the prosecution team, good morning to the honorable judges, distinguished guests, and members of the public. And in particular, welcome to the victims, witnesses, and community representatives here today. We know that you've endured a long journey to be here, not simply in terms of travel, but more significantly in light of all that you have experienced. We're grateful for your resilience, your courage, and your trust in sharing your experiences with us and the world. My name is Doreen Chen, and together with my colleague Azura Amin, we have the honor of leading the prosecution team at this first permanent People's Tribunal on Myanmar. Over the next 3 days, we will be presenting to you the prosecution case. The first half of today's hearing aims to provide the public and the judges with a general introduction to the prosecution case. I'll begin with a brief roadmap to the proceedings. I will then present the indictment that has been formally submitted to the tribunal before I turn to discuss some key issues, in particular questions of international law that that we hope the evidence presented will address. Next, Prosecutor Amin will take the floor to present a high-level introduction of the specific cases we're bringing on behalf of the three communities whose situations are the focus of these hearings. After the morning tea break, we'll deliver a short audio-visual presentation. The purpose of this presentation is to offer both the public and the judges with a visual representation of the mass atrocity crimes that we allege to have occurred in Myanmar. Given our very limited time, we've focused only on a high-level selection, in particular, eyewitness footage of crimes, testimony of victims and experts, and other visual data, such as satellite images and photographs. We would especially like to stress that half of the audiovisual presentation contains eyewitness accounts from victims that have been gathered directly from IDP camps in the last few days, specifically for the purposes of this tribunal, by the filmmaker Jafiur Krakman. These are the most up-to-date, direct accounts of the most recent military operations of the Burmese military in Rakhine State in August and September. And given their special topicality, we've included them in full. The audiovisual presentation will be followed by a segment featuring the testimony of two expert witnesses who will be able to provide detailed, expert information focused on key overarching themes. These include the nature of the crime of genocide, and Myanmar's military and political structure and distribution of power. Two additional experts will also speak briefly during this session, but will offer more detailed testimony on Tuesday during the presentation of evidence in relation to the Rohingya. And then, after the lunch break, and on Tuesday and for much of Wednesday, we will be moving to the factual evidence relating to each community whose cases are before this tribunal. This evidence will include the live testimony of victims, witnesses, and experts who can offer insight into the events that have occurred, the crimes that we allege to have been committed, and the military and state policies that have given birth to them. While the majority of this evidence will be delivered in open court, due to serious security concerns, certain witnesses will be testifying in confidential sessions with only the judges present. In addition, some witnesses will testify in open court with the audience present, but with their testimony not being broadcast on the live stream. While we understand that it is frustrating that some of the tribunal's evidence will not be aired publicly, the security of the witnesses who are generously sharing their experiences with the tribunal must be paramount, and we thank you all for your understanding in this regard. And now there are a number of additional matters which we, the prosecution, wish to mention before we turn to a presentation of the indictment itself. And the first point we wish to stress is that the most unique feature of this tribunal is the extent to which these proceedings are driven by the victims. This is far more so than in traditional international tribunals. At the Permanent People's Tribunal, victims have had a direct line to the judges. They've had the opportunity to submit requests for the judges to investigate and determine whether the state of Myanmar has committed mass atrocity crimes, and to provide evidence supporting their claims. In effect, therefore, it is the victims and their communities who have defined and driven the tribunal's mandate and the content of the ensuing prosecution case. In particular, it is the victims who have selected the crimes we have included in the indictment, and which they argue are the crimes that best fit the atrocities that have been committed against them. Our resulting case at this stage addresses the situation of the three communities who submitted requests to the judges within the time limit for this specific hearing. These communities are the Kachins, the Rohingyas, In the spirit of community and multiculturalism, each community will have an equal opportunity to present evidence. Given the time constraints of these hearings, this will be 5 hours of hearing time per group. We will begin with a presentation of Kachin evidence later today and tomorrow morning. This afternoon, we will briefly switch from hearing Kachin evidence to hearing the testimony of a representative of the Bangladeshi Human Rights Commission. That commission has travelled here today to provide a first-hand account to us of the situation currently unfolding on the Myanmar-Bangladeshi border. And this situation, obviously, is that involving the Rohingya people. Then tomorrow we will continue to hear evidence on the Kachin group, followed by evidence relating to the Rohingya community. And finally, we will be hearing evidence on other Myanmar Muslims for most of the day on Wednesday, before concluding the prosecution case. It's also important for us to stress that the current hearings build upon earlier hearings held in London in March of this year. At those hearings, evidence was already presented to the judges, which the judges will be able to refer to in drafting the judgment if they wish. In particular, evidence was offered in March relating to the situation of the Rohingyas. In light of that, and in light of recent developments in Rakhine State and on the Myanmar-Bangladeshi border, the evidence presentation in relation to the Rohingyas at this September hearing will differ slightly from that of the Kachin and Myanmar Muslims. As you will see tomorrow, the Rohingya session will focus more specifically on most recent developments to ensure the utmost currency of these proceedings and the tribunal's findings. It's also important for us to note that there is additional evidence on top of that which will be heard live in this courtroom. In particular, since March, the judges have been provided with a wide range of documents that support the prosecution's case. Much of this evidence includes eyewitness accounts, which we humbly request the judges to consider when preparing their judgment. This evidence is often of particular significance for certain sensitive crimes where it is more difficult to obtain live evidence here in the courtroom, and this is most particularly so in relation to the crime of rape and other forms of sexual violence. It's also important for us to note that although these hearings focus on the situation of the Kachin, Rohingya, and Myanmar Muslim communities, this tribunal is open to considering the situation of other groups at a later point in time. And if time permits, there will also be a possibility for representatives of other communities to address the tribunal at these hearings after the prosecution case has concluded. With that said, I will now present the indictment which the prosecution submitted to the tribunal in August 2017, following submissions from the 3 communities. The indictment. Whereas the Permanent People's Tribunal is a public opinion tribunal based on the Universal Declaration of the Rights of the Peoples, on all the instruments of international law, and on the inherent rights of people. Whereas the various chapters of the Permanent People's Tribunal have sought to struggle against impunity and to promote respect for human rights, access to justice, and the reappropriation of the human rights instruments. Whereas the Permanent People's Tribunal adjudicates flagrant, systemic, and systematic violations of the rights of people and of vulnerable individuals. Whereas the mission of the Permanent People's Tribunal is to promote universal and effective respect for the fundamental rights of peoples by determining if these rights have been violated and examining the causes of these violations, as well as denouncing their authors before world public opinion. Whereas the Burma-Myanmar state sustains the military through the establishment of an institutional, political, financial, and judicial system that favors military supremacy. Whereas major obstacles exist in Myanmar for affected communities when seeking justice at the national and international level, which promotes impunity for human rights violations. Having accepted the Rohingya complaint filed November 2016 and the Kachins complaint filed March 2017, the Permanent People's Tribunal opening session on the 6th of March 2017 heard accusations by representatives of the Kachin and Rohingya groups of a range of state crimes committed by the Burma Myanmar state. In support of those accusations, the panel of judges heard a very wide range of victim and expert testimony from a variety of sources, leaving no doubt of the veracity of the claims behind the accusations. The Permanent People's Tribunal further accepted the Myanmar Muslim complaint filed July 2017. The accused. The Myanmar state, which includes departments of government, the extensive military complex, the police, the border police, senior members of the ruling National League for Democracy Party, the President, Hin Kuo, and State Councillor Aung San Suu Kyi, stands accused of the following crimes with relation to the Kachin and Rohingya ethnic groups and the Muslim population. State-sponsored and state-led massacres, extrajudicial executions, murders, disappearances, drownings, rape and sexual violence, the destruction of homes and of whole villages, the wholesale denial of civil rights in the context of state terror, gross, widespread and systematic violations of the right to life, economic and social and cultural rights, particularly the right to health and livelihood, the right to food and food sovereignty, and the right to freedom from interference with the family and home, all in the context of systematic and targeted state violence and terror. Furthermore, there is evidence of gross, widespread and systematic violations of civil and political rights, particularly the right to self-determination of peoples, the right to participation in political and social life, and violations of women and children's rights. While not within the purview of this indictment, the prosecution recognizes the significant role of Myanmar language media outlets, Rakhine ultranationalists, and extreme anti-Muslim Buddhist organizations, including elements of the Burmese Sangha, in the dissemination of anti-Muslim and anti-Kachin propaganda, hate speech, and ideology in furtherance of and to garner public support for the state's persecution of these groups. Furthermore, the prosecution recognizes the role of the international community and international organizations in negligently turning a blind eye to crimes and human rights abuses against the victim groups in Myanmar, and continuing to offer political support to the Myanmar military and NLD-led government despite their treaty obligations to act. The prosecution accordingly reserves the right to continue to investigate and to prosecute these entities at a later date. The charges: international crimes against Myanmar Muslims, war crimes and crimes against humanity against the Kachin people of northern Burma, genocide and crimes against humanity against the Rohingya people, serious violations of human rights of Myanmar Muslims and the Kachin and Rohingya people. We base these charges on the inherent rights of people, domestic Myanmar law, and on international law. We recognize that these crimes and human rights abuses are disproportionately penetrated against and experienced by women and girls. The indictment is not limited in its temporal scope and and does not bar the inclusion of examining the culpability of other states or non-state actors, which could include, but is not limited to, corporations and civil society organizations. The Tribunal remains open to participation from other groups alleged to have suffered crimes for which the accused may be responsible. Particulars. The indictment is not limited in its subject matter scope and does not bar the inclusion of examining other possible crimes for which the PPT may consider the accused responsible. Victim groups have requested the PPT to specifically investigate the following crimes. For the Kachins, charges against the Myanmar state for war crimes and crimes against humanity against the Kachin people of northern Burma. Targeting of civilians, rape, the use of sexual violence as a weapon of war, arbitrary detention, slavery, forced labor, restriction of provision of humanitarian assistance, including healthcare and food to internally displaced people, IDPs. 1. The extermination or murder of Kachin civilians, including women, children, and the elderly, by military forces. 2. Rape and other forms of sexual violence as a weapon of war by the Burma-Myanmar military. 3. Extrajudicial executions, torture, enslavement, and arbitrary detention. 4. The destruction of cultural and religious monuments, including churches. And 5. The willful creation of over 120,000 IDPs. For the Rohingya, the Burma-Myanmar state is responsible for genocide and crimes against humanity, including the targeting of civilians, rape, the use of sexual violence as a weapon of war, arbitrary detention, forced labor, restriction of provision of humanitarian assistance to internally displaced people, IDPs. You have already heard specific testimony in relation to 1. The extermination or murder of thousands of Rohingya Muslim civilians, including women, children, and the elderly. 2. The prolonged detention of tens of thousands of Rohingya Muslims in camps, ghettos, and villages within Rakhine State, Burma/Myanmar, under conditions of life calculated to bring about the partial physical destruction of those groups, namely through starvation, overcrowding, forced labor, inadequate medical care, and constant physical and psychological assault. 3. The imposition of restrictive and discriminatory measures against Rohingya Muslims, such as the restriction of freedom of movement, removal from positions of authority in local government institutions and the police, dismissal from jobs, arbitrary searches of their homes, denial of the right to citizenship, judicial process, and the denial of the right of equal access to public services, including proper medical care and education. 4. The intentional and wanton destruction of homes, other public and private property belonging to Rohingya Muslims, their cultural and religious institutions, historical monuments, and other sacred sites. Such destruction was employed as a means to compel Rohingya to flee their homes and communities and to prevent their subsequent return. 5. The obstruction of humanitarian aid, and in particular, medical and food supplies. And finally, the Myanmar Burmese Muslims. Myanmar Muslim victims request for the PPT to investigate the following charges of Myanmar international crimes and human rights abuses: hate speech, racial religious discrimination, hate crimes, anti-Myanmar Muslim riots, looting, burning of Muslim houses and places of worship, and mass murders by successive Myanmar military governments in the whole of mainland Myanmar since 1962. Widespread institutional discrimination, state-sponsored hate crimes, mass killings, wholesale destruction of communities and neighborhoods, massive forced displacement, apartheid structures of segregation, targeted population control, state denial of Myanmar Muslim identity, forced labor, systematic rape and other forms of sexual violence, and denial of access to livelihood, healthcare, freedom of movement, and food. That concludes the presentation of the indictment, and I will now turn to address a number of general issues we, the prosecution, wish to raise in contextualizing the case presented to you. I would like to begin by recalling for the Tribunal the words of a far more illustrious international prosecutor than our humble team here at the bench. I refer to none other than Robert Jackson, who was the chief prosecutor for the United States at the Nuremberg Tribunal, trying the most senior surviving leaders of Nazi Germany. Over 70 years ago, Robert Jackson opened the trial at the Nuremberg Tribunal by saying this: "The wrongs which we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated." Let me also cite the words of former US President Bill Clinton. Nearly 20 years ago, in 1998, President Clinton said the following about the genocide that had just been committed in Rwanda: "We did not act quickly enough after the killing began. We did not immediately call these crimes by their rightful name, genocide. And we must have global vigilance, and never again must we be shy in the face of the evidence. Never again." This is the mantra we hear time and time again when it comes to mass atrocity crimes. Never again. That human civilization should have moved beyond this point to one of greater enlightenment, fraternity, and peace. Never again. That our efforts as an international community should now focus on prevention rather than punishment. Never again. And yet, here we are. This tribunal does not operate in a historical vacuum. Unlike more traditional international tribunals, it is not bound by a very formal temporal jurisdiction in terms of the time frame of the events it is permitted to consider. Therefore, we in the prosecution feel it is not only impossible for us to avoid mentioning the proverbial elephant in the room, but also unnecessary. So let's address it. As everyone in this room and listening in to these hearings would well appreciate, these hearings are incredibly and unfortunately timely. Right at this very moment, some 400,000 Rohingya civilians have been streaming over the border from Rakhine State to Bangladesh in recent weeks. Men, women, and children running for their lives, fleeing from villages burning and from attacks by military forces in the largest flare-up of military operations to take place in recent years. The most recent reports have suggested that up to 10,000 people fled in a single day. For perspective, this is nearly 70 times more than the number of people in this room right now. 70 times more. It's hard to even fathom. It's clear, therefore, that despite the enduring popularity of the never again mantra, the reality is quite the opposite. History is continually repeating itself. And 70 years after the Nuremberg Tribunal, we are here again, staring down into the abyss of the worst aspects of the human condition and hearing accounts of victim experiences that we thought should have been condemned to a dark and distant chapter in human history. But these events did not occur spontaneously in only August of this year. To the contrary, they reflect a long history of conflict between the Rohingya and Myanmar, and systematic policies of persecution and discrimination stemming back from several decades. The same can equally be said of the situation of the Kachin and Myanmar Muslim groups. And yet, for years, there has been a deafening silence from the international community around the plight of all three communities, as well as that of other ethnic and religious minorities in Myanmar. This silence has ensured impunity for mass atrocity crimes in Myanmar, particularly within the last decade, and since Myanmar has ostensibly reopened itself to the world. And it is a silence that is only now really starting to break, in the last couple of weeks. In this context, the primary purpose of the prosecution case is to bear witness. Thanks to the generosity and the courage of the victims and witnesses who have agreed to appear, our case will focus on offering the tribunal eyewitness accounts of what the three communities have suffered. We will also focus on hearing these accounts in the victims' own words, as much as possible honouring the victims' way of presenting their narrative. And we will do this by avoiding a classic courtroom style of prosecution examination, and instead we will begin with a prepared statement that each victim will offer, followed by questions from you, the judges. The factual details that the victims and witnesses will be able to offer you will establish conclusively that the alleged international crimes, namely crimes against humanity, war crimes, and genocide, together with serious violations of human rights, have indeed been committed. And they will show that it is the state of Myanmar which bears responsibility for the commission of these crimes. Moreover, the direct evidence you will hear will definitively overturn the claims circulated recently that alleged atrocities are the product of so-called fake news or propaganda. The evidence you will hear will also be important in overturning another popular recent claim, and that is that any actions by Myanmar's military against minority groups such as the Rohingya is justified if the actions are a reaction to a provocation by armed elements within the group. However, a cornerstone of international law is that any military or state reaction must be necessary and proportionate when assessed in relation to the instigating action. The evidence you will hear clearly shows that this is not so, and that these military actions are highly disproportionate. As you will hear, it also clearly shows that the very vast majority of those who have suffered under military operations have been civilians. They have been, in particular, women and children. The bottom line is that there can be no justification for such indiscriminate and highly destructive military operations. And it's important to stress that such military actions not only violate principles of customary international law that exist everywhere, regardless of treaties, but they also violate some of the few treaties to which Myanmar is actually a party. And these include the Convention on the Elimination of All Forms of Discrimination Against Women and the Convention on the Rights of the Child. Turning to another issue, the prosecution notes that last week, the United Nations Secretary-General Antonio Guterres was asked during a press conference whether the situation that the Rohingyas are currently facing could be considered to be so-called ethnic cleansing. And the Secretary-General answered as follows. Well, I would answer your question with another question. When 1/3 of the Rohingya population had to flee the country, could you find a better word to describe it? Although the Secretary-General asked that question in an apparently rhetorical fashion, the answer to that question is in fact, yes. Yes, there is a better way to describe it. And let us first explain that answer by looking at the term ethnic cleansing. ethnic cleansing does not refer to a crime under international law as such. Unlike genocide, war crimes, or crimes against humanity, ethnic cleansing is not criminalized in its own right under international law. Ethnic cleansing is only criminalized under international law to the extent that each of its underlying acts can be considered a genocidal act, a crime against humanity, or a war crime. Nevertheless, it is a term that has been around for decades. It rose to particular prominence during the conflict in the former Yugoslavia, and it has become very popular, not only with the media, but also with, for example, the United Nations. Indeed, although it does not have an identity as a standalone crime, it is one of the crimes that could trigger the United Nations application of the principle of the responsibility to protect. And the constituent acts of ethnic cleansing include not only forced displacement, as we know well, but also a great deal of other possible crimes. Crimes against humanity, in fact, and war crimes, such as killing, torture, and forced transfer, among others. Indeed, when you look at the way in which the term is popularly used, what unites them is that they are always part of an underlying and systematic campaign of persecution against a specific group. Now, this is critical for the prosecution's case when it comes to the Rohingya group specifically. For what we will be arguing, and which our expert witnesses will particularly focus on, is that the treatment of the Rohingya by the state of Myanmar through the actions of the military and the omissions of the civilian administration amounts under international law to genocide. And what we will argue is that this is proven through establishing the existence of an underlying and systematic campaign of persecution and discrimination against the Rohingya. As you judges well know, genocide, the so-called crime of crimes, requires proof of an intent to destroy in whole or in part a group as such. Under the Genocide Convention, to which Myanmar has long been a party, genocide can be carried out through a range of acts. Not only does this include killing members of the group, but it of course includes, among other things, deliberately inflicting on the groups conditions of life calculated to bring about their physical destruction in whole or in part. Although indeed the Rohingya have been displaced on a massive scale, this does not undermine the argument that the group's ultimate physical destruction is indeed intended. For as the evidence presented, and in the documents and in past hearings shows, the conditions that have been imposed on the Rohingya within Myanmar systematically and for decades are precisely conditions of life calculated to bring about their partial destruction. Now, the previous Special Rapporteur on the situation of human rights in Myanmar, Thomas Quintana, has publicly spoken of a gag rule that exists within the United Nations that prevented him from ever announcing that the situation of the Rohingyas amounted to genocide. A rule which apparently prevents any United Nations leader from using the term genocide to apply to any modern situation of alleged mass atrocities. Now, it is clear that with the clear statement of the United Nations Secretary General Antonio Guterres last week, and the cacophony of other similar statements from others, there is now something of a paradigm shift beginning when it comes to Myanmar. His statement is a step forward in that it finally brings the international community at least halfway down the road towards the genocide label. Calling the situation a clear example of ethnic cleansing defines it clearly as a crime against humanity, a war crime, or a serious violation of human rights. What is needed now is to travel down the remaining half of the road. We need to call the situation by its proper name, and that name is genocide. And this is what we hope our case will prove and what the judges at this tribunal will find. And turning to a final issue, we at the prosecution have endeavoured to frame our case around the more anthropological approach that the institution of the Permanent People's Tribunal represents. Our case, thus, has been fundamentally driven by the victims. And therefore, as we mentioned earlier, the primary focus of our case is on bearing witness, giving the victims a forum within which to present their truth in their words, and to help, in this sense, to perhaps contribute to creating some form of peace. At the same time, there can be no peace without justice. Therefore, it is also critical from the prosecution's perspective that this tribunal contribute to establishing accountability for the mass atrocities to which the Kachin, Rohingya, and Myanmar Muslim communities have been subject. Therefore, the parameters of international law, though not overtly mentioned in our case, underlie the way we in the prosecution have framed every aspect of it. In our selection of evidence, we have focused on providing the judges with the necessary evidence to establish key elements required under public international law as it relates in particular to state responsibility for internationally wrongful acts, to international criminal law as it relates to individual criminal responsibility for mass atrocity crimes such as genocide and crimes against humanity, which are considered criminalized everywhere regardless of what treaties a particular country has signed, to international humanitarian law as it relates to war crimes, and in particular to violations of Common Article 3 of the Geneva Conventions, which is applicable in non-international armed conflicts, and to international human rights law and the most serious violations it identifies, in particular rights that are today considered to have the force of customary international law, again, regardless of what treaties a state has signed. The live evidence you will hear in court over the next few days primarily focuses on establishing that criminal acts have been committed. As briefly mentioned earlier, this is supplemented by evidence in the documents provided to the judges, in particular where it has been difficult to obtain live evidence, for instance in the case of sexual violence. Evidence from experts and the documents provided to you, the judges, will generally focus instead on establishing the link between criminal acts and the responsibility of the state of Myanmar and the possible responsibility of other individual actors or organizations. This link is, in the form of, for example, policies and statements that establish criminal intent, including the intent to destroy a group in whole or in part as needed for genocide, and in particular the establishment of widespread or systematic attacks as are required for establishing crimes against humanity. We certainly recognize that definitive legal proof of such crimes will necessitate lengthier and more intensive processes. Nevertheless, we, the prosecution, believe that this tribunal can and should act as a prominent stepping stone in that journey, and that it can contribute to ending impunity, and most importantly, that it can assist in some way in improving the lives of members of the Kachin, Rohingya, and Myanmar Muslim communities. I will now hand the floor to Prosecutor Amin to continue our opening statements by providing you with further insight into the evidence we will be hearing over the next few days in respect of each community. Thank you very much.
Thank you, Chief Prosecutor. And I would like to stress that as a People's Tribunal, we also thank the courage of the victim witness who decided to give testimony before the tribunal, and we will try to honor that courage in our judgment. So please.
Honorable judges, over the next 3 days, we will be hearing testimonies from witnesses on the atrocities committed against the Rohingyas, Kachins, and other ethnic minorities. The prosecution team has identified and divided the witnesses into 3 different groups, namely the Rohingyas, Kachins, and Myanmar Muslims. We have expert witnesses and direct witnesses giving their testimonies before the distinguished panel of judges at the hearing today. Today, we will be hearing and we will be ministering key audio-visual evidence presentation, followed by the expert evidence on the general context. For the general context, we will hear from Dr. Mauzani, who will be testifying on the evolution of policies of the military towards the Rohingyas. We will also hear from Dr. Greg Stanton, who will be testifying on the comparative view of genocide. And finally, we will also hear from Ms. Razia Sultana, who will be testifying on sexual violence against women, rape, harassment, and torture. Ms. Razia was recently, on the 8 to 9 September, has recently completed a mission at the border of Bangladesh, particularly at Teknaf and Kutupalong. This will be followed by testimonies by the Kachin communities. The prosecution has identified 8 key witnesses who have agreed to come forward and to provide their testimonies to this tribunal. The 8 witnesses on the list will be covering the specific themes on atrocities in the Kachin conflict, killings, arbitrary detention, and sexual violence. The testimonies by the Kachin communities will continue into a session tomorrow morning. And as for the second day, the prosecution shall present to the panel of judges key expert witnesses and witnesses from the Rohingyas communities. We will hear from Mr. Joe Ang, who is a Burmese Muslim expert, and he will be testifying on the role of the civil society organizations in Myanmar in spreading the atrocities against the Rohingya communities. We will also hear again testimony from Ms. Razia Sultana, who has recently completed a mission at the Bangladeshi border, Teknaf and Kutupalong. She will present to the tribunal visuals of the most recent situation of the refugees at the border. We will also have 4 witnesses from the Rohingya community in Malaysia. On the last session in March this year in London, the Malaysian legal team had interviewed and presented evidence based on their interviews with 33 Rohingyas witnesses residing in Malaysia. Honorable judges, the task of interviewing the 33 witnesses was not easy. Currently, there are about 56,000 Rohingya refugees scattered throughout 9 states in Malaysia. The Malaysian legal team managed to identify about 10 to 15 Rohingya refugee settlements in the Klang Valley, particularly within the vicinity of Kuala Lumpur, and managed to interview up to 100 refugees for the past 3 months prior to the London Tribunal. The target of the Malaysian legal team was to interview a group of witnesses who have personally experienced and were eyewitnesses to events surrounding violence committed in Myanmar in the year 2012 and later. Before the commencement of the formal audio-visual interview, the Malaysian legal team undertook a preliminary assessment of the Rohingya refugees sought to be interviewed before accepting their testimonies for the purpose of the above stated assignment. Among the matters determined were, number 1, that the interviewee would be an authentic member of the Rohingya community based on his or her state-issued documents or earlier testimonies or family tree records, as well as official confirmation from the head of the settlement they lived in Malaysia for the purpose of the interview. Number 2, that the interviewee came to Malaysia after the violent incident of 2012 and later, and not prior to the same. Number 3, that the interviewee came to Malaysia by force in order to escape ongoing violence and violations of their human rights, and not because of other purpose, for example, economic reasons. And number 4, that the interviewee's testimonies are based on her or his own personal experience, what they felt and what they have eyewitnessed, and not something they heard from others or any other hearsay evidence. The scale of the undertaking of the Malaysian legal team quickly became apparent when many of the Rohingya refugees sought to be interviewed, refused to give formal evidence out of fear, yet their family members still residing in Myanmar would be subject to a greater danger of being assaulted, beaten, or murdered should they be identified. Due to these constraints, out of almost 100 witnesses, the Malaysian legal team decided to limit the compilation of testimonies and accounts to only 35 witnesses for the purpose of the London Tribunal. The testimonies were fully recorded in audio-visual form and translated into the Malay language by the Myanmar interpreter. Then the testimonies were transcribed and further translated into English to ensure that the testimonies were given voluntarily without force or without any kind of inducement, as well as given without fear or favor. The interviewer, viewer, and the interpreter then executed a statutory declaration to this effect and affirmed the same before a notary public. The Malaysian legal team strongly believed that the evidence submitted to the London Tribunal, by virtue of these strict conditions and due process observed in the taking of the testimonies, transcripts, and audiovisual evidence of the same testimonies, the testimonies, transcripts, and audiovisual evidence of the same are fit to be used in any international court and will withstand any level of scrutiny. Prior to the start of any interview, as a matter of the due process, and in order to observe necessary legalities, the witnesses were reminded to speak the truth and were also further reminded that they were under oath to speak the truth. The interpreter was also asked to take the oath before all interviews to ensure the necessary legalities and the truthfulness of their interpretations were duly observed. Honorable judges, during the London Tribunal, the Malaysian legal team had classified the testimonies of the witnesses of 4 types of violations as follows. Number 1, violations of fundamental rights, particularly denial of citizenship, isolation, discrimination, denial of fundamental basics such as education, job, electricity, and water. The rest, number 2 is rape, violence against women, and sexual violence. And number 3 is violation against personal rights, which include physical assault, beatings, and forced disappearance. And finally, violations against the right to life, which is killings, murders, and systematic genocide. We will also have four witnesses from the Rohingya currently residing in Malaysia. And as an addition to that, there will be also 2 witnesses from among the women rape victims who has requested for their testimony to be given in camera. On the last day, we shall hear from the representatives of the Myanmar Muslim communities, and we will then invite the Chief Prosecutor, Mr. Chen, to present the prosecution closing statement. With that, I thank you.
Okay, well, thank you very much. I don't know if any member of the panel has a general question to the prosecution team. Otherwise, maybe we should take a little break, 20 minutes. So 10 or